There are situations where a strong litigation approach would be to consider a global litigation strategy as opposed to just a domestic litigation strategy. I can give you an example. If you're trying to recover a debt against a debtor, and that debtor may have assets worldwide, and not just assets, but may have different citizenships worldwide, then you have to consider the possibility, which can be very real, that whenever you start a case, that person will shift those assets outside of the jurisdiction. And there are different approaches you can take to try to preclude that. In order to be able to analyze that issue from the get-go, you can't just be thinking narrowly in terms of where am I suing? Let's call it, I don't know, Oklahoma or California, right? Because if you're doing that, what will happen is the debtor will most likely immediately shift assets or just move outside jurisdiction if they even have to be in the jurisdiction. So what you want to do is you want to analyze what are the debtor's likely next moves, right? And then at least consult with counsel in those other jurisdictions in terms of what potential alternative options could be. They may be to pursue litigations in parallel in different jurisdictions. They may be to be able and ready to act in each particular jurisdiction if you need to. For example, trying to obtain a freezing order in the United States and or UK simultaneously or in conjunction with one another. Situations differ, and each case is different. Not every case calls for a global litigation strategy. Sometimes it's very specific to a particular county or state. But in international business cases, especially with international debtors, they may be immigrants to the United States that have other connections somewhere else they can easily flee to. You do have to consider the global impact of the case.